this month.
So, very good morning, all the participants. Today, we'll try to cover some of the provisions regarding general awareness. So, in general awareness, one of the important things is writs. And I've already made you, all of you as co-hosts, so you can keep on adding people whosoever joined. So, writs, they are covered in Part 3 of the Constitution. So, they provide for the Part 3 of the Constitution provides for legal remedies for the protection of these rights. And if you are interested in reading, then I am also reading from this book. I hope it is visible. If it is not, Our Constitution. The book is Our Constitution. Just let me share video setting. Okay. Now I think it will be more visible. Is it visible now? So this is the book. The book is Our Constitution by Subhash C. Kashyap. A very brief book published by National Book Trust. And I think all of us should read this book if we are interested.
Which book, sir?
This book is Our Constitution. Is it
Ah.
visible?
Okay.
Our Constitution, it is written by Subhash C. Kashyap. An introduction to India's Constitution, and I'll post a pic in the group also.
Okay, sir.
So Part 3 of the Constitution, it provides for legal remedies for the protection of these rights against their violation by the state or other institutions or individuals. So it entitles the citizens of India to move the Supreme Court or High Court for the enforcement of these rights. The state is forbidden from making any law that may conflict with the fundamental rights. So the first thing, if a person is not a citizen of India, whether he can file a writ. So they will ask you questions like this. I hope my question is clear.
Yes, sir.
So let us make it interactive. So if a person is a foreign citizen, whether he can file a writ.
The fundamentals are given to Indian Constitution only, no? Indian
Yes.
citizens.
So foreign companies and fundamental rights. I'll post this in the group also. So,
Foreign companies क्या है, sir?
हाँ जी.
Foreign companies क्या है?
Foreign companies, those who are established outside India.
Okay.
So let me share this also with you. Just a minute. So let us go through this, because they will try to ask you questions which are not normal.
Yes, sir.
Again, so let me share this also with you. So foreign companies and fundamental rights. Let me share this screen also with you. Because if they ask us this question, we should be able to answer. So let us devote 5 minutes to this. I hope now it is visible on your screen. Okay. And I have shared this in the group also. Is it visible?
Yes, sir.
Yes, just a minute. Just let me share it again. So the question is, Supreme Court, in the case of Tata Engineering Locomotive Company Limited versus State of Bihar and others, has held that the company is a natural person and has its own life. A well-settled proposition in law is that these incorporated persons are entitled to the protection of fundamental rights as granted under the Constitution, which are as wide as to cover all persons. However, the scheme of protection under fundamental rights available to a company not incorporated under the Companies Act does not stand in equal footing. So, pertinently, by foreign company and foreign national are not to be confused and used interchangeable for the purpose of availability of fundamental rights. In the case of Louis D. Red versus Union of India, the Honorable Supreme Court upheld the right of foreign national to take recourse to writ jurisdiction for enforcement of the fundamental rights. However, it shall not be wrong to state that the law is far from being settled in cases involving the rights of a foreign artificial person. So, Supreme Court has already held, in this case, Louis D. Red versus Union of India, they upheld the right of foreign national to take recourse to writ jurisdiction. So, a foreign national can also file a writ jurisdiction. Now, foreign companies, non-citizens and writ jurisdictions. So, the Constitution does not provide for any categoric bar on invoking of the writ jurisdiction by a foreign entity. The basic requirement for invoking the jurisdiction of the writ courts is the breach of the legal right by any person or authority who fits the description of state under Article 12 of the Constitution of India. Okay. In exceptional cases, a person or authority who is not state within the meaning of Article 12 of the Constitution can also be subjected to the jurisdiction of the writ courts. The very initial judicial pronouncement done by the High Court of Judicature at Calcutta in the matter of Hong Kong and Shanghai Banking Corporation versus Union of India, wherein the Honorable Court, while examining the very maintainability of the writ petition filed by a foreign company under Article 226 of the Constitution, upheld the right of foreign entity to invoke the writ jurisdiction. Observing further, the Honorable Court held that this position would not change in respect of a company incorporated outside this country. A foreign company in any event has a right to sue, and there is no bar under the Civil Procedure Code also in that regard. Evidently, the Honorable High Court also held that Article 19 is not available to foreign entity. Okay. The question as to the availability of which fundamental rights are available to foreign entity and which are not available to foreign entity had remained a concern for the courts, which is far from settled as on date. In the year 2011, the Honorable High Court of Judicature at Calcutta in Airbus Engineering Company Limited versus State of Bengal held that Article 15, 16 and 19 are not available to foreign entity. In interpreting so, the court relied primarily on two sources. First, Article 367 and secondly, the intent of the framers of the Constitution. While relying on the former, the court noted that the definition of the word person under the General Clauses Act can be resorted to and taken shelter under Article 367 for the purpose of interpretation. And secondly, the intentional use of the word citizens and persons by framers of our Constitution, because these are available to citizens of India. So we can just jump to the conclusion. So even though foreign companies have been afforded protection under Article 14 of the Constitution, the law on the applicability of other fundamental rights is now well settled. Though most of the writ jurisdiction filed by the foreign companies alleging violation of the Article 14 are in essence to get rights under Article 19, which is a prominent abuse of the process of law. In cases like Cosmos Tours and Travels versus Union of India and the Power Measurement versus UP Power Corporation, the incorporated foreign entities attempted to abuse the process of law through alleging violation of Article 14, but in actual enforcing rights under Article 19, which are not available to foreign entities. So courts have been consistent in criticizing such abuse of writ jurisdiction by foreign entities. However, a lot more clarity and certainty is to be laid down by the honorable courts in future in this regard. The Honorable High Court of Delhi, in the case of Thompson versus National Airport Authority of India, while dealing with the challenge by a foreign entity to the tendering process under writ jurisdiction, upheld the right of foreign entity to mount such challenge, averring infringement of Article 14 of the Constitution on the ground of duty of the state to measure its action in the threshold of meeting of Article 14. The court further held that the fundamental rights conferred by Article 15, 16, 19, and 29 can be invoked by citizens alone. Rights created by Article 14 is granted to the individual or person, irrespective of the fact that whether the individual is foreign or a citizen or an alien or it is an artificial person. So we can conclude that 14 is available to all, but 15, 16, 19, 29, they are available to citizens only. So some articles, relief under some articles is available to all the persons, and relief under some articles is available only to the citizens. Accordingly, we have to interpret. ठीक है, चलिए. I have shared this screen also with you. So now let me go to the original PPT, general awareness. This also has been shared in the group. Right. Okay. So what is a writ? Writs are actually written orders issued by the Supreme Court of India to provide constitutional remedies to protect the fundamental rights of citizens from a violation. Facts about writs in India. Article 32 also empowers Parliament to authorize any other courts to issue these writs. Before 1950, only the High Courts of Calcutta, Bombay, and Madras had the power to issue the writs, and Article 226 empowers all the High Courts of India to issue the writs. Writs of India are borrowed from English law, where they are known as prerogative writs. Now, what is a writ petition? A writ petition is essentially a court petition. So, when you apply for the enforcement of your fundamental rights, you file a writ petition. And when the court orders, so that is a writ. So, what is a writ petition? A writ petition is essentially a court petition for extraordinary review, asking a court to intervene in a lower court's decision. You can directly approach the Supreme Court or the High Court for enforcement of your fundamental rights, bypassing the hierarchy of courts. So a writ petition is essentially a court petition for extraordinary review, asking a court to intervene in a lower court's decision. Under the Indian legal system, jurisdiction to issue prerogative writs is given to the Supreme Court and the High Courts of Judicature of all India states. Parts of the law relating to writs are outlined in the Constitution of India. So what are the types of writs? First is the habeas corpus. You may have the body. Second is mandamus. We command certiorari to be certified, prohibition, stay order, and quo warranto, by what warrants. Now habeas corpus. Police picks up a criminal and takes him to police custody. When the family members go there, police station says nobody is here. So that means that person, because normally there is a provision in the law that within 24 hours you have to produce that person to the magistrate. But sometimes what the police authorities do, they, in order to extract information, they don't show his formal arrest. So first of all, they will try to establish his guilt and then they will show his arrest. So that is why they keep him under custody, but without bringing it on records. So what is the remedy available to the family members? So they can file a writ before the High Court or the Supreme Court. This habeas corpus writ petition they can file. So habeas corpus is a writ that is enforced to protect the fundamental right to liberty of an individual against unlawful detention. So they say whenever you want to detain, you show his formal arrest. This is the meaning. So this writ commands a public official to deliver a detained person in front of the court. So the court will ask, you produce that person before us, whether dead or alive, and provide valid reasons for the detention. However, this writ cannot be issued in case the proceeding is for contempt of a legislature or a court. This is the first. Second,
habeas corpus, only family members can file, sir.
No. Anybody can file. All these writs can be filed by any person. Basically,
Sure.
normally these are filed. These are filed
Hmm.
by law-abiding citizens. So anybody can file. No issue. Certiorari. The writ of certiorari is issued to a lower court directing that the transfer of a case for review, usually to overrule the judgment of the lower court. So certiorari means the right of being heard. The writ of certiorari means hearing. Certi means certain. The writ of certiorari is issued to a lower court directing that the transfer of a case for review, usually to overrule the judgment of the lower court. The Supreme Court issues the writ of certiorari in case the decision passed by the lower court is challenged by the party. It is issued in case the higher court finds it a matter of over jurisdiction or lack of jurisdiction. So, the higher court will issue a writ of certiorari that okay, you bring all the records before us. Suppose some Supreme Court judge finds a article in the paper that okay, this court has passed such decision. So if they see it is a matter of over jurisdiction or lack of jurisdiction or it has not been passed properly, so they may issue a writ of certiorari. It is one of the mechanisms by which the fundamental rights of the citizens are upheld. So certiorari, you can remember it this way: certain of being heard. Corpus means body, so habeas corpus, have the body. Prohibition. Prohibition is a writ, and normally they will ask you one question on this, on either of these writs. What is the meaning? So prohibition is a writ issued by a higher court to a lower court to enforce inactivity in the jurisdiction. So it happens only in case the higher court is of the discretion that the case falls outside the jurisdiction of the lower court. So writ of prohibition can only be issued against judicial and quasi-judicial authorities. So basically they will say that you don't act in this. So it is a writ issued by a higher court to a lower court to enforce inactivity in the jurisdiction, that you don't exercise this jurisdiction. So it happens only in case the higher court is of the discretion that the case falls outside the jurisdiction of the lower court. So writ of prohibition can only be issued against judicial and quasi-judicial authorities. Next is mandamus. The writ of mandamus issued to a subordinate court, an officer of the government or a corporation or other institution commanding the performance of certain acts or duties. Unlike habeas corpus, mandamus cannot be issued against a private individual. So they can ask you this question also, whether the writ of mandamus can be issued against an individual. The answer is yes. Suppose one individual has kidnapped the other. So writ of habeas corpus can be issued against such individual. But this mandamus, it cannot be issued against a private individual. So this is issued to a subordinate court, an officer of the government or a corporation or other institution commanding the performance of certain acts or duties. This is mandamus. So the writ of mandamus can be used to order the completion of a task, say the completion of a road or a bridge, or in other cases, it may require an activity to be ceased. Like suppose some demolition activities are taking place. So this writ of mandamus can be issued, preventing the municipal authorities from exercising the powers of demolition. So this is mandamus. Next is quo warranto. Quo warranto is issued against a person who claims or usurps a public office, because you can assume a public office only by way of some authority. Through this writ, the court inquires by what authority the person supports his or her claim. Through this writ, the court inquires into the legality of a claim of a person to a public office. So this writ prevents the illegal assumption of a public office by an individual. So these are the various types of writs. Now the right to constitutional remedies. So we'll cover some of the basic provisions. And in the group, you can write a few things. The first question which you can note down is, what rights are available? Say, we can say applicability, article-wise applicability. So KB Kumarji, please work on this. Article-wise applicability. Which articles are available to all individuals or persons, and which articles are available to citizens of India only? This may be.
Sir.
So article-wise applicability to individuals or citizens of India. So we can write it in a tabular format. We can, on the left-hand side, we can write the name of the article. Article 14, 19, 21, let's say. On the right-hand side, we can make two columns: available for individuals, available for citizens of India only. But we can write like this. Now, suspension of fundamental rights. So fundamental rights can be suspended. It will be beneficial for all. So fundamental rights can be suspended in the case of national emergency, as mentioned under Article 352. The 6 fundamental rights under Article 19, they are automatically suspended in case national emergency imposed on ground of war or external aggression, which is stated under Article 358. Article 359 has the clause for suspension of other rights. In that case, a separate notification has to be issued by the President. The rights mentioned under Article 20 and 21 can never be suspended. And constitutional emergency and financial emergency cannot affect the fundamental rights. So there are different types of emergencies. We can work on this also. National emergency, constitutional emergency, financial emergency. We can work on this also. So Supreme Court is the highest authority to uphold the Constitution of India, to protect rights and liberties of citizens, and to uphold the values of rule of law. Hence, it is known as the guardian of our Constitution. The Supreme Court is the final court of appeal in all civil, criminal, and other matters, thus helps in maintaining a uniformity of the law throughout the territory of India. The Constitution and jurisdiction of Supreme Court is stated in detail from Article 124 to 147 of the Indian Constitution. So, Constitution of the Supreme Court, Article 140, 124. Appointment of judges, so you can go through this. Appointment of Chief Justice, tenure of office, qualifications, removal, salaries and allowances, acting Chief Justice, ad hoc judges, Supreme Court as the court of record, 129. This is important. So the Supreme Court of India is a court of record and has all the powers associated with such a court, because there are two types of courts. Some are court of records, others are not. Like these metropolitan magistrates, so they are not court of records. So sometimes they record summary of the proceedings, not all the proceedings. Okay. Similarly, family courts, they are not court of records. But the Supreme Court and the High Court, they are court of records. Everything, whatever is said, that is recorded. So Supreme Court of India is a court of record and has all the powers associated with such a court. A court of record has the following powers: the power to determine its own jurisdiction and the power to punish for its contempt. Article 131, original jurisdiction. So there are certain matters on which the Supreme Court has got the original jurisdiction. Normally, Supreme Court is not a court of original jurisdiction, but in certain important matters, suppose there is a dispute between the center and the state, or there is a dispute between the center and a state on one side and a state on the other side, and two or more states. So in these cases, the apex court has the exclusive original jurisdiction. Okay? No lower court can decide these things. So Supreme Court pointed out that Article 131 is attracted only to those cases involving disputes between or among states and the union in the context of the constitutional relationship that exists between them and the powers, rights, duties, liabilities, immunities, etc. flowing therefrom. Exclusion of original jurisdiction. The Constitution excludes the jurisdiction under Article 131 in the following matters: disputes arising out of any treaty, agreement, covenant, engagement, or other similar instrument which have been entered into or executed before the commencement of the Constitution, continues in operation after such commencement, or which provides that the said jurisdiction shall not extend to such a dispute. So Parliament may, under Article 262, to exclude Supreme Court's jurisdiction in adjudication of any dispute or complaint with respect to the use, distribution, or control of the waters in any interstate river or river valley. Appellate jurisdiction, Article 132. So Supreme Court has jurisdiction over all the cases that come to it as an appeal against the judgment of the High Court, only when it has the certificate of a case involving so a certificate has to be accompanied when you file an appeal, that it involves a substantial question of law as to the interpretation of the Constitution under Article 134A. Such a certificate can be obtained only in the following situations: if an appeal lies only from any judgment, decree, or final order of the High Court, no appeal lies from an interim order. The case should deal with civil proceedings, criminal proceedings, and cases raising a substantial question of law as to the interpretation of the Constitution. The decision on the question of constitutional law should be necessary for the proper decision of the case, and the question involved must be a substantial question, a question regarding which there is a difference of opinion and which needs to be decided by the Supreme Court. Appeal by special leave. Article 136. So Article 136 1 empowers the Supreme Court of India to grant in its discretion special leave, SLP, special leave to appeal from any judgment, decree, this is very popular, SLP. Yeah? Special leave to appeal from any judgment, decree, determination, sentence or order in any cause or matter passed or made by any court or tribunal in the India. Okay? Exclusion of jurisdiction. Article 136(2) excludes the judgments or order passed by a tribunal functioning under the armed forces. ठीक है. केस है दिल्ली जुडिशियल सर्विस एसोसिएशन वर्सेस स्टेट ऑफ गुजरात. So Supreme Court has plenary jurisdiction to grant leave and hear appeals against any court or tribunal. After the Supreme Court grants leave to appeal, the court hears the appeal on merits. After hearing the arguments of the parties, the court gives its discretion. Now power to review, Article 137. So Article 137 enables the Supreme Court to review its own judgments subject to the provisions of any law made by Parliament. This power is exercisable under rules made by the court under Article 145. Grounds of review. A review will lie in the Supreme Court on the following grounds: discovery of new important matters of evidence, mistake or error on the face of the record, and any other sufficient reason. 142, very important article, and sometimes they ask question in the exam. Okay, Article 142 deals with. So Article 142 empowers the Supreme Court the power to do complete justice. So Article 142 empowers the Supreme Court to pass any decree or judgment necessary for doing complete justice in any matter or cause. Any such decree passed by the Supreme Court shall be made enforceable throughout the territory of India in such manner as may be prescribed by or under any law made by Parliament, and until provision in that behalf is so made in such manner as the President may by order prescribe. 142. 143 is advisory jurisdiction. Under Article 143(1), the Supreme Court has the jurisdiction to advise the President of India on matters referred to it for obtaining the apex court's opinion. Okay? So sometimes the government also asks the opinion of the Supreme Court on certain matters. So Article 143. The scope of this jurisdiction is very wide, as the President can seek the opinion of the Supreme Court on any question of law or fact which appears to him to be of such a nature and public importance that it is expedient to obtain the court's opinion. When such a reference is made, it has to be listened to by a bench of not less than 5 judges. The Supreme Court is not bound to give advice and may refuse to give its advisory opinion for strong reasons. Article 32, writ jurisdiction. The Indian Constitution empowers the Supreme Court to issue writs for the enforcement of any of the fundamental rights conferred by Part 3. These are the types of writs which we have already seen: habeas corpus, mandamus, certiorari, prohibition, and quo warranto. Now, state judiciary. The state judiciary consists of a high court and a system of courts subordinate to the high court within the territory of the state. So Article 214 of the Constitution establishes high courts in state. Okay. Article 216, Constitution of High Courts. 217, qualifications, appointment, terms of office, removal, salaries and allowances, jurisdiction. As a court of record, the principle of sanctity of recitals in court proceedings is available to the High Court. So High Court is also a court of record. So only the Supreme Court and High Court are courts of record. It also gives every High Court the right and the power to punish a contempt of itself. The Supreme Court in M.M. Thomas versus State of Kerala observed that a court of record enveloped all such powers whose acts and proceedings were to be enrolled in a perpetual memorial and testimony. Being a court of record, the High Court has a duty to keep its records correctly and in accordance with law. Okay. Pre-constitution jurisdiction, writ jurisdiction, Article 226, Article 32, Supreme Court, Article 226, High Courts, writ jurisdiction. Writs against final judgment of the Supreme Court to the High Court is not possible. Okay? Because if a remedy was not available under Article 32, the same would also not be available under Article 226. Suppose you filed a writ under Article 32 to the Supreme Court. That writ was rejected. Okay? Now you cannot file a writ in the High Court. ठीक है, because if remedy was not available under Article 32, the same would also not be available under Article 226. A writ petition before the High Court for reopening of examination in a Supreme Court's judgment is clearly untenable in law. ठीक है, writ is a discretionary remedy. They may or may not accept. Article 226 provides an extraordinary remedy, which is essentially discretionary, although founded on legal injury. This remedy, therefore, cannot be claimed as a matter of right. It will be exercised only in furtherance of interest of justice, in furtherance of public interest, and not merely on the making out of a legal point. Thus, any party seeking relief in equity must come to the court with clean hands. Supervisory jurisdiction. So we can go through. Now, let us see some of the rights of workmen under labor laws in India. So the central government proposes to replace 29 existing labor laws with 4 codes. The objective is to simplify and modernize labor regulations. So President of India on 29th September assented to the 3 bills, namely the Industrial Relations Code, Social Security Code, and the Occupational Safety, Health and Working Conditions Code, passed by the Rajya Sabha. So the 3 bills were passed by the Lok Sabha on 22nd September 2020, amalgamating and simplifying 29 labor laws. The first of the 4 codes proposed by the government, the Code on Wages, was passed by Parliament in 2019. However, the codes are yet to be implemented. Now, trade unions. Payment of Wages Act. So, Section 6 of the Wages Act 1936 says that workers must be paid in money rather than in kind. Okay. Minimum Wages Act. Maternity Benefit Act. So, as per this act, female workers are entitled to a maximum of 12 weeks, 84 days of maternity leave. All the organized and unorganized offices that have more than 10 employees shall implement this act. So, they can ask you a question. Maximum permissible leave, 12 weeks, 84 days, applicable to all organized or unorganized offices having more than 10 employees. The Maternity Benefit Act was amended in 2017 to increase the maternity leave entitlement from 12 weeks to 26 weeks for the first 2 children. POSH, Sexual Harassment of Women Employees at Workplace. So this act is also applicable to all public or private and organized or unorganized sectors that have more than 10 employees. Industrial Disputes Act. Factories Act. So Section 18 of the Act specifies regarding arrangements for sufficient and pure drinking water for the workers. Okay. There should be sufficient accommodation for urinals. Section 21 of the Act provides for proper fencing of the machinery. It should be properly fenced. Contract labor, bonded labor, equal remuneration. So these are the questions which you can go through. Before we move to the other part, let me take just a minute. So is my screen visible now? So this book, I'll read some of the provisions from this book. So this is a book on labor laws from which they might ask you questions. So just let me read some of the important provisions from this book. Regarding PF. Regarding PF, I think you all know what should be the contribution from the employer and employee? In PF, it should be 12% of the pay. Both employer and employee contribute at the rate of 12% of pay to Provident Fund. Okay. 8.33 contribution of employer goes to Family Pension Fund and balance is credited to employee's PF account. They can ask you interest rate also. You can check with the latest rate, but the rate as per this book is 8.5%. Employee whose pay is less than 15,000 per month is covered under the Act, PF Act. So pay includes basic wages, dearness allowance, retaining allowance, and cash value of food concession. Employee State Insurance Act, at least 10. The factory means any premises where manufacturing process is carried out and persons employed are at least 10. Okay. So employees drawing wages up to 21,000 per month are presently covered under the ESIC scheme. Earlier, this limit was 50,000. Now, employees up to 21,000 per month are covered under ESIC scheme. Employees' contribution is 1.75%. Employers' contribution is 4.75% of the wages. Okay. And this contribution has to be paid within 21 days. Otherwise, interest at the rate of 12% is applicable. In Factories Act. So factory means any premises where 10 or more workers are working and a manufacturing process is carried out with the aid of power or without the aid of power, 20. Facilities. So there are some stipulations regarding facilities in case of large factories. So ambulance requirement will be there. Ambulance room if 500 or more workers are employed. Canteen if 250 or more workers are employed. Okay. Restrooms, shelters with drinking water when 150 or more workmen are employed. Crashes, crash के बारे में पूछ लेते हैं. तो crash if 30 or more women workers are employed. Full-time welfare officer if factory employs 500 or more workers. Safety officer if 1,000 or more workmen are employed. Okay. Overtime, when overtime is applicable. If a worker works beyond 9 hours a day or 48 hours a week, overtime wages are double the rate of wages are payable. तो एक बार केबी कुमार जी ये लिख दीजिएगा ग्रुप में, नहीं तो मेरे को बता दीजिएगा, मैं इसका स्क्रीनशॉट भेज दूंगा बुक का.
ओके सर.
So I got very high hopes from you. Wages भी हो गए. Payment of bonus act applicable to any factory employing 10 or more persons or other establishment where 20 or more workers. Minimum bonus 8.33%, maximum 20%. इतना तो याद होना ही चाहिए कम से कम, है ना. और किस पर एप्लीकेबल है? एम्प्लॉय हुज सैलरी वेजेस एक्सीड ₹21,000 पर मंथ.
ESI के लिए भी 21,000 ना सर?
हाँ, ESI भी 21,000. यस. अब ग्रेचुटी में क्या बोल रहा है? ग्रेचुटी में बोलता है एट कंप्लीशन ऑफ एटलीस्ट 5 years ऑफ सर्विस. ये वैसे भी मालूम ही रहता है जनरली लोगों को. एंड ग्रेचुटी इज एप्लीकेबल टू ऑल एम्प्लॉयज इररिस्पेक्टिव ऑफ द सैलरी. ग्रेचुटी में सैलरी में का इशू नहीं है, इसमें मिनिमम कंडीशन नहीं है सैलरी की कितनी होनी चाहिए. So gratuity is payable to a person on resignation, termination, on account of death or disablement, due to accident or disease, retirement, death. Normally, gratuity is payable only after an employee leaves after completing 5 years of continuous service. In case of death and disablement, the condition of minimum 5 years service is not applicable. ये भी important है. Section 4 subsection 1 of payment of gratuity act. तो death हो जाए या disablement हो जाए तो minimum 5 years वाली condition भी नहीं लगेगी. ठीक है. मैक्सिमम ग्रेचुटी कितना है? 20 lakhs. चलिए, ये भी कुछ प्रोविजंस कर लिए. अब आगे देखते हैं. Now regarding economy. In economy, they will ask you a question on the different terminologies which are used in economy. ठीक है. तो टर्मिनोलॉजी में एक वो क्वेश्चन जो नॉर्मल पूछते हैं वो ही पूछते हैं, भाई गिग इकोनॉमी क्या है? व्हाट इज अ गिग इकोनॉमी? एनी आइडिया? ये गिग इकोनॉमी क्या होती है?
नो सर।
भाई जैसे ये जोमेटो, ठीक है, ये सारे जो चल रहे हैं ना, ये गिग इकोनॉमी का ही पार्ट है, बेसिकली पार्ट टाइम वर्कर्स, फ्रीलांसर्स. So gig economy is a labor market characterized by short-term flexible jobs, often facilitated through digital platforms, where individuals or companies offer services on a temporary or task-by-task basis, rather than through traditional full-time employment contract. तो ये है गिग इकोनॉमी. ये पहले तो बहुत पूछते थे, आजकल थोड़ा कम कर दिया इन्होंने पूछना, बट थोड़ा आइडिया होना चाहिए होती क्या है गिग इकोनॉमी. ठीक है. नाउ आई थिंक यू शुड बी एबल टू आंसर. तो ये होती है गिग इकोनॉमी. ये मैं इसमें भी डाल देता हूँ. So gig economy is labor market characterized by short-term flexible jobs, often facilitated through digital platforms, where individual or companies offer services on a temporary or task-by-task basis, rather than through traditional full-time employment contracts. ठीक है, चलिए. अच्छा, अब बाकी इकोनॉमी पे कुछ और क्वेश्चंस देख लेते हैं. जीडीपी क्या है ना, ग्रॉस जीडीपी, नेट जीबीटी, जीडीपी. माइक्रो इकोनॉमिक्स क्या है, मैक्रो इकोनॉमिक्स क्या है, दे कैन आस्क यू एनी क्वेश्चन ऑन दिस. आई हैव गिवन दिस चार्ट, है ना, ये मेरा स्क्रीन विजिबल है ना?
हाँ.
हाँ. तो ये इलास्टिसिटी ऑफ डिमांड. भाई डिमांड इज परफेक्टली इलास्टिक इन विच सिचुएशन, है ना, परफेक्टली इन इलास्टिक किस तरह से? भाई परफेक्टली इलास्टिक डिमांड कब होगा? व्हेन ए वेरी सिग्निफिकेंट चेंज इन प्राइस लीड्स टू एन इन्फिनिट चेंज इन क्वांटिटी डिमांडेड, सो इट इज कॉल्ड परफेक्टली इलास्टिक. ठीक है. भाई महंगा हो जाएगा तो नहीं खरीदेंगे, कम सस्ता हो जाएगा तो खरीद लेंगे. कुछ ऐसा होता है चीजें जो चाहे महंगी हो चाहे सस्ती हो, आपको खरीदनी है. आटा आपको खरीदना ही खरीदना है कि नहीं? तो दैट इज यूजुअली एसोसिएटेड विद नेसेसिटीज, परफेक्टली इनइलास्टिक डिमांड. भाई आटा जितना भी महंगा हो जाए थोड़ी नहीं खरीदोगे, आप तो खरीदोगे ही. जो लग्जरी प्रोडक्ट्स होते हैं उसमें क्या होता है कि डिमांड इज रिलेटिवली इलास्टिक. ठीक है. सो व्हाट
Elastic
इज
means change, na?
Yes, yes. So elasticity means the ratio of percentage change, quantity in demanded supply to percentage change in some other factors like price or income. ठीक है. So suppose price changes, then whether your demand or supply will change. That decides the elasticity. If your demand will change, then we will say that the demand is elastic. If the supply will change, we'll say supply is elastic or inelastic. है ना? तो ये जब आप चार्ट देखोगे तो आपको हो जाएगा क्लियर. Relatively elastic, relatively inelastic, is perfectly elastic, perfectly inelastic, इस तरह से they can ask a question on this. Financial markets. Sometimes they ask you question on bonds. Bonds के बारे में कई बार क्वेश्चन पूछते हैं. जैसे मसाला बॉन्ड क्या है? कुछ आइडिया है क्या होता है मसाला बॉन्ड? ऐसे पूछता है सवाल वो. भाई मसाला बॉन्ड क्या है? जो इंडियन सप्लायर्स हैं, अगर ये फॉरेन में जाते हैं, वहां पर कोई बॉन्ड्स इशू करते हैं, उसको हम कहते हैं मसाला बॉन्ड्स. ठीक है. मसाला बॉन्ड्स आर बॉन्ड्स इशूड आउटसाइड ऑफ इंडिया बट डिनोमिनेटेड इन इंडियन रुपीज. इनको कहते हैं मसाला इज ए हिंदी वर्ड दैट ट्रांसलेट्स टू स्पाइसेस. द टर्म वाज इनिशियली कॉइन्ड बाय इंटरनेशनल फाइनेंस कॉर्पोरेशन टू व्यू द कल्चरल एंड क्यूलरी एसेंस ऑफ इंडिया. तो इसको हम कहते हैं मसाला बॉन्ड्स. ठीक है. इशूड आउटसाइड इंडिया बट डिनोमिनेटेड इन इंडियन रुपीज, ये मसाला बॉन्ड है. ये तो कॉपी नहीं हो रहा इसमें, कॉपी तो होना चाहिए, चलो छोड़ो, यहाँ से दे देते हैं। मैं इसका लिंक शेयर कर देता हूँ। एंड ये जो है ना, ये क्वेश्चन कई बार पूछ चुके हैं ये।
कौन सा मसाला बांड है?
हाँ हाँ हाँ, ये इनके उसमें है, जो क्वेश्चन बैंक होता है ना, उसमें क्वेश्चन है। तो ये भी मैंने लिख दिया, मसाला बॉन्ड्स आर बॉन्ड इशूड आउटसाइड इंडिया बट डिनोमिनेटेड इन इंडियन रुपीज। चलिए, एक बुलडॉग बॉन्ड क्या होता है? बॉन्ड
हम्म,
डिनोमिनेटेड इन स्टर्लिंग बट इशूड बाय ए नॉन ब्रिटिशर बोरोवर इज नोन एज बुलडॉग बॉन्ड, इसको कहते हैं बुलडॉग बॉन्ड। तो बॉन्ड्स के बारे में आप थोड़ा सा रिसर्च कर लीजिएगा, व्हाट आर द वेरियस टाइप्स ऑफ बॉन्ड्स। ठीक है, बाकी ये तो मैं शेयर कर ही दूंगा आपसे। बकेटिंग क्या होता है? बकेटिंग इज अ सिचुएशन वेयर in an attempt to make a short-term profit, a broker confirms an order to a client with actually executing it, without actually executing. Bearer bonds are securities which do not require registration of the name of the borrower. Chinese walls. Chinese walls are artificial barriers to the flow of information set up in large firms to prevent the movement of sensitive information between departments. Dabba trading. Dabba trading is the trading of securities outside the stock exchange. Green shoe option. Green shoe option is an option of allocating shares in excess of the shares included in the public issue and operating a post-listing price stabilizing mechanism in accordance with the specific provisions in DIP guidelines, which is granted for a company to be exercised through a stabilizing agent. जंक बॉन्ड क्या है? जंक बॉन्ड इज हाई यील्ड बॉन्ड इशूड बाय लो रेटेड कंपनीज, पूछ लेते कई बार। तो बॉन्ड्स के बारे में आपको कम से कम 5-7 तरह के बॉन्ड है ना याद होने चाहिए। जंक बॉन्ड, मसाला बॉन्ड, बियरर बॉन्ड, बुलडॉग बॉन्ड, इस तरह से। चलिए, नाउ फाइनेंशियल फ्रॉड्स एंड रोल ऑफ प्रोफेशनल इन इन्वेस्टिगेटिंग फ्रॉड्स। तो यू कैन गो थ्रू दिस पीपीटी ऑल्सो कि इसमें क्या क्या चीज है। तो दे कैन, बिकॉज ये फोरेंसिक ऑडिट भी हमारे सिलेबस में है। तो फोरेंसिक ऑडिट व्हाई, हाउ इट इज डिफरेंट फ्रॉम द नॉर्मल फाइनेंशियल ऑडिट? So basically, financial audit is usually a sampling activity that does not review every transaction. ठीक है? Now, but forensic audit, they looks at the details of a specific aspect of an organization's books and records. So objective is to understand why and how the fraud has occurred. So as a result, forensic audit is much more time consuming and significantly more expensive as a procedure than a regular financial audit. ये ऑडिट है, ये फोरेंसिक्स है। तो यू कैन गो थ्रू दीज थिंग्स जितना आप कर सके। स्कोप ऑफ वर्क क्या होता है इन 43 एंड 44? सो व्हाट यू विल डू, you will analyze the nature of the related party transactions and their impact on the financial statements. So verification, you will verify whether payments or receipts have been done in accordance with the transaction. Then impact of any offset journal entries that may have been passed and its impact. Investigation of a preferential transaction not at arm's length between entities that have taken place in the following manner: in case of related parties, 2 years prior to the date of insolvency; in any other case, 1 year prior to the date of insolvency. ठीक है? Examination of transfer of property, assets, interest to the benefit of a particular creditor beneficiary in the presence of an existing debt liability such that the creditor is in a beneficial position at the time of distribution of assets. तो इसको आप इस से भी रिलेट करके पढ़ सकते हो। ठीक है, ये थोड़ा सा इंपॉर्टेंट है, इसको आप जरा जरूर पढ़ लीजिएगा। फाइनेंस में क्या है? फाइनेंस में देर आर सर्टेन बेसिक एस्पेक्ट्स, तो लेट अस सी व्हाट आर द बेसिक एस्पेक्ट्स। एक तो रिस्क रिटर्न का ट्रेड ऑफ है। व्हाट इज दिस रिस्क रिटर्न ट्रेड ऑफ? सो इट सेज हायर द रिस्क हायर द रिटर्न एंड लोअर द रिस्क लोअर द रिटर्न। ठीक है। तो on the safe side of the spectrum, risk-free rate of return, it is represented by the return on government securities. ठीक है, as their chance of default is essentially zero. Thus, if risk-free rate is 6% at any given time, for instance, this means that investors can earn 6% per year on their assets, essentially without risking anything. Cost averaging investments. So this is a method in which a fixed sum is invested on a regular basis, irrespective of the market trends. Thus, more shares are bought when the market prices are low and less when they are high. एसेट एलोकेशन। एसेट एलोकेशन इज एन, एक कोई भी टर्म ले लेंगे, उसके ऊपर एक क्वेश्चन सेट कर देंगे आपको। कुछ आइडिया होना चाहिए होता क्या है ये एसेट एलोकेशन। एसेट एलोकेशन इज एन इन्वेस्टमेंट स्ट्रेटजी दैट एम्स टू बैलेंस risk and reward by apportioning a portfolio assets recording to an according to an individual's goals, risk tolerance, and investment horizon. Efficient market hypothesis क्या है? कि share prices reflect all information. It is impossible to purchase low or sell high. Technical analysts disputes this theory of this efficient market. ऐसा कोई efficient market होता नहीं है। Portfolio optimization क्या है? Investors behave rationally, minimizing risk and maximizing returns. Capital asset pricing model. Expected return of a particular security or a portfolio is equal to the rate on a risk-free security plus a risk premium। ठीक है, ये कैपिटल एसेट प्राइसिंग मॉडल है। कॉस्ट ऑफ कैपिटल क्या है? कॉस्ट ऑफ इक्विटी प्लस कॉस्ट ऑफ डेट, वेयर बोथ आर मल्टीप्लाइड बाय अप्रोप्रिएट वेटेजेस। ठीक है, तो रिस्क फ्री रेट ऑफ रिटर्न प्लस बीटा ऑफ एक्सपेक्टेड मार्केट रिटर्न माइनस रिस्क फ्री रिटर्न, ये कॉस्ट ऑफ इक्विटी है आपकी। What are these? There are various decisions in finance, financing decisions, investment decisions, ठीक है, return on capital employed, dividend decisions। बहुत सारी रेशियोज हैं, तो ये रेशियोज भी आप एक बार देख सकते हैं। रेशियोज के लिए आई रिकमेंड यू ए बुक। ये माइक्रो इकोनॉमिक्स की एक बुक है। ये मैक्रो इकोनॉमिक्स है और एक माइक्रो इकोनॉमिक्स की ये जनरल इकोनॉमिक्स, ये भी एक बुक है। जनरल इकोनॉमिक्स इज ऑल्सो ए बुक दिस। ये अपना इंस्टीट्यूट ऑफ चार्टर्ड अकाउंटेंट्स का है, तो यहां से भी आप देख सकते हैं। ये मैंने कुछ क्वेश्चंस भी सेट किए हैं इसके ऊपर, तो दीज क्वेश्चंस यू कैन गो थ्रू। ठीक है जी, आंसर्स भी दिए हुए हैं इनके।